Hi, I'm attorney Jay Farrow, and one of the most frequently asked questions I get is, what does it mean exactly that your law firm is revolutionizing the practice of law? Well, it relates to our approach to the practice of law, which has a vision and mission to get people in and out and on with life, as opposed to getting stuck in years of unending and unrelenting litigation that leads to wasted time, money, aggravation, and sleepless nights. So how do you accomplish that? How do you create an approach that challenges the status quo? The status quo of client walks into a lawyer's office and hears the facts of the case, drafts a lawsuit, and files the lawsuit, and off you go into litigation land. That is the tried and true method of the practice of law. That is conventional thinking, is that we will take any legal claim and drop it into litigation. But once it gets into litigation, everyone is at the mercy of the court system. Its delays, its procedure, and its advantages specifically to the defendant. And I'll get to that in a bit. Our approach, which we've been developing over the last 5 years, relates to doing all of our homework up front. Getting our clients' facts is just the start of things, but getting all of the emails and all of the text messages and performing all of the legal research and drafting a lawsuit that provides for the facts, the timeline, the claims, and serving that lawsuit before things ever get started. What do I mean by that? I mean, prepare a lawsuit as if you are preparing for war, as if you were preparing to file it actually in court. But don't file it in court just yet. Serve it upon the defendants in the case and offer the opportunity to go to what's called a pre-suit mediation. Now, a pre-suit mediation, for those who are unfamiliar with the process, is where the two parties agree to have a third party, sometimes a retired judge, or what's called a certified mediator by the Florida Supreme Court, to go between the parties, listen to their claims, listen to the defenses that are raised, and to give a perspective on the value of claims, the strength of legal arguments. And also, it's one thing for our clients to believe in their case, and it's another thing for us as the lawyers representing the clients to believe in their cause as well. But to hear the perspective of a third party is invaluable, especially before you're about to endeavor into a very costly and aggravating process of litigation. But also, if you do it in the pre-suit context, you give both parties the opportunity to resolve their differences, to resolve their claims, such that the legal dispute is over in a matter of months rather than a matter of years. And you could tack on years to that if you even consider the possibility of one of the sides appealing the decision of a court. Now, in the pre-suit context, and asking specifically for a mediation, it's important to note one thing, and that is that every single case, whether it's federal or state, now has a requirement, and has for some time, to go to mediation. So you will find yourself at a mediation at some point if you decide to just go that traditional route and file the lawsuit and go into litigation land for a couple of years. You will find yourself at that table with that person. Now, most cases nowadays, and this is why our approach, I think, is so revolutionary, most cases, when they start out, are not whodunits. It's like, you know who did it. you know who's on first. This is not a puzzle that needs to be solved. Now, when you know who's done it, the idea is how are you going to prove it, right? Because you still need the evidence that you would prepare or collect to submit to court one day. Well, amazingly enough, technology has provided an answer that feeds into our approach, which is that most people communicate by email. Most people communicate by text or some other form of electronic means. Not too many of us are using that old beat up fax machine, but that actually works just as well. Because all of this electronic information has data associated with it. What does it have? It has who sent what to whom, the date, the time, and the exact message that was communicated. Now, in the context of disputes in closely held businesses, this is even more fundamental as far as evidence is concerned, because most individuals in closely held businesses have sent over email the terms of a deal. They've sent over contracts to their partners or third parties. They've sent over letters of intent, memorandums of understanding, operating agreements, and the discussions that were happening to give clarity to exactly what was meant by these agreements. In other words, you have exactly what you need at the beginning of most lawsuits that you would have to present to court anyway. So the revolutionary concept that we have is, why not do everything up front? Put all of your cards on the table, and yes, maybe hold some back for strategic purposes, but draft a lawsuit that contains all of the facts supported by evidence such that you can serve it on the other side, and it's like game over or checkmate in most circumstances, because you've now identified not only what your story is, but what evidence that you have to back up those claims. So if you were to go before a third party or a mediator, and if you were to go before a retired judge, they're going to analyze what you put down on paper just like it would be a couple of years from now by a judge or jury. So why not take that opportunity? Why not take that initial step, do that step of doing all of your homework up front, all of your analysis, all of your research? Because not only do you have all of the emails and the text messages which provide for the discussions between two parties, but you also have things that they've said online in the past about themselves. In closely held businesses, most of my clients are upset at their partner who has been in other businesses before, who has a LinkedIn page, who has a Facebook page, who has said things about themselves in prior instances where you can say or point to, look, this is what this person identified themselves as being, and that was completely false, or it was completely accurate. Now, imagine a world where you have all of this information in your hands when you walk into a lawyer's office for the first time, and you have an opportunity to save yourself the expense and the time, the aggravation, and those sleepless nights to end that dispute in a matter of months. How do you do that? Not only do you prepare the lawsuit, you serve it out on the other side, you conduct a pre-suit mediation, and you get to hear what the other person's side of the story is. And you also get to hear from a third party, not your lawyer and not you or your friends, what this may look like at the end of the day, giving you a perspective that you would never have had you not taken this process. It might very well be that no matter how strong you think that your claim is, you're missing a piece that you'll never be able to have, which will end up losing a case at trial. And while that might be something you don't want to hear, it's something that you need to hear. So when we revolutionize the practice of law, or we say that we're revolutionizing the practice of law, it relates to an approach that challenges conventional thinking and also focuses on all of the things that you need to do anyway during the case, but doing it up front, doing it in advance. And here's one of the things that I wanted to bring up that is possibly even more beneficial to just attending the pre-suit mediation. It's this. Again, the cases are not a whodunit to begin with. You have all of the information that you possibly need in your own hands at the beginning of the case. But here's what you also get to discover. You get to discover what your defendant or bad guy or fraudulent partner is going to say to defend themselves. Imagine that. Not only do you know what your story is, but you're going to know what their story is before the lawsuit even gets filed. Now, for the advantage of information, or from the perspective of know thy enemy, imagine having that in your hands before you even have to file a lawsuit. Because one way or the other, your bad guy, defendant, fraudulent partner, or a business relationship that didn't work out, they have their side to the story, and it may have some value. You'd be surprised to know that maybe it wasn't exactly what you thought. But to have that information will only make your case stronger if you have to go the conventional route. Because by that time, you not only have your facts, you have what the other side is going to say, and then you get to proceed with the advantage of information. And that advantage is truly revolutionary.